We'll give it about a minute before we get started to let everyone get in. Okay, it's been about a minute, but I also see people still coming in. So in about 10 seconds, I'll get started. Okay. Good afternoon and welcome to today's webinar, IEPs and 504s post the executive order. My name is Monica McHale Small, and I'm the Director of Education for the Learning Disabilities Association of America. Thank you to everyone who's here today that is a member. And for those of you who are not, I urge you to become one. Membership comes with some great benefits, such as discounts on our conference and exclusive webinar content. But most importantly, membership is our voice. You may not be aware that LDA was founded as a collaboration between parents and researchers, most prominently Dr. Samuel Kirk. Dr. Kirk coined the term learning disabilities at a conference organized by parents who were working towards ensuring their children received appropriate education and support in our public schools. It was as a direct result of that work that learning disabilities was included as a classification in what is now the IDEA. Our strong voice through our many members throughout the country resulted in advancing the rights of students with learning and other disabilities to a free and appropriate public education. Once again, our voice is needed to ensure our children get the education they need and deserve. The more members we have, the stronger our voice. So please consider becoming a member. Before we get started, just some housekeeping. We will use the Q&A for questions. Feel free to submit them throughout. For technical issues, please use the chat. Everyone who's registered will get a link to the recording and any handouts in a few days. And now I would like to introduce our speaker, Ms. Heidi Goldsmith. Ms. Goldsmith has been serving the needs of children and families in the area of special education for around 25 years, I believe. Prior to founding Bradley and Goldsmith Law, she practiced law at McAndrews Law Offices. During her 19 years at McAndrews, Ms. Goldsmith became a shareholder of the firm and was supervising shareholder of special education for almost 10 years. Ms. Goldsmith is the parent attorney representative to the Stakeholders Council of the Office for Dispute Resolution in Pennsylvania. She has frequently spoken at national and statewide special education conferences, including LDA and COPA. Ms. Goldsmith offers substantial expertise in the area of special education. I first met Heidi more than 15 years ago when I was a school district administrator. At that time, we sat on opposite sides of the table. Despite a history of representing different interests, Heidi and I grew to respect each other's expertise and passion for serving children. LDA is fortunate to have Heidi as a member of our professional advisory board. At this time, I'd like to invite Heidi to take it away.
Hello all. Okay, so I kind of had this idea and I talked to Monica about it was because I feel like we're back in kind of the COVID time periods, right? Where there's a lot of stuff that is happening. It's all coming from different areas and trying to understand kind of how it's going to impact our kids with disabilities with IEPs and 504s is really confusing, scary, and we don't know what the future holds. And to a certain extent, we don't. We're kind of in an unknown, unwritten time period with a lot of different competing streams, which I'll talk about because they're all kind of running on the same track in terms of but different directions. So kind of let's just start with kind of the most recent stuff that has been happening regarding kids with disabilities. Obviously, the biggest impact right now has been the Department of Education and the March 20th, 2025 executive order. And really, just so we're on the same page, because there is a lot of misunderstanding of what the Department of Education does. The Department of Education does not run your state's curriculum. The Department of Education does not run what, the books your district picks. That is all done at state and local levels. What the Department of Ed does do, though, is oversee IDEA and Section 504 and Title IX. And that's the federal laws. And that's really the enforcement in terms of IDEA and 504 that was a critical piece to for kids with disabilities. It also distributes funds for those like Title IX, or not Title IX, Title I, um, other funds and research for grants that districts have for kids with disabilities, as well as providing guidance and research. And by that I mean is one of the key components that all of us who practice in not only education law, but also as school districts, and I'll be frank, I'm actually a school board member of my public school. But one of the things that districts look to is the Department of Ed and how to interpret and go forward in implementing IDEA in Section 504. And let me just give you a couple of examples. So during COVID, when we had situations, and we all did, of learning loss, it was the Department of Ed that put out the guidance that said, hey, for kids with disabilities, you have to do COVID compensatory services, and gave a framework. Without that guidance, though, that was not occurring, and that would not have occurred. And in fact, when the guidance was initially given, it only was for kids with IEPs. Subsequent guidance came out from the Department of Ed that talked about it also applying to kids with 504. And then kids with 504 was able to access that. And that's just a small snippet of kind of what that guidance is. Oftentimes, states would write in to get guidance on how to interpret regulations because unfortunately, the way IDEA is written, and you could say fortunately or unfortunately, is that it's broad. And the specific scenarios are oftentimes confusing. And so people look to the Department of Ed to say, how do we interpret this? How do we do it? So that is some of the areas that the Department of Ed did. So what does that mean now? One, the EO set forth a time frame to transfer kind of, and I'm not going to talk about this, but the student loan debt servicing to the Small Business Administration. But in terms for kids with disabilities, those programs and services are now going to be overseen by the Human Health Services. That has already supposed to have started to occur. To what extent that transfer has done, that is unknown to what services have actually gone over, what is still being done by the Department of Ed, whether or not the Department of Ed employees that are doing it are just now considered human health services. That's right now unclear. But what has already occurred is the Office for Civil Rights, which was the enforcement wing of the Department of Ed. And when we're talking about OCR, it's the Office of Civil Rights, you could, as a parent, and you still can, um, if you felt your child was being discriminated against, not receiving supports and services under IDEA or Section 504 or Title IX, file what's known as an OCR complaint. That has already been cut down to a significant lower staffing level. And as a result of that, there were, at least in Philadelphia, 17,000 cases that had been left unresolved at the time the staffing was reduced. And so we don't know how long those time frames are going to take for those complaints to be investigated. Um, the other thing that the EO did is set forth kind of a reduction of all unnecessary services. So the program eliminations are occurring. One of the most recent cuts was $600 million for training for teachers. That has been now cut, and that was upheld by the Supreme Court. And that's kind of what I want to take a step back on because I know I'm throwing a lot at you in a short period of time. But where we're at right now in and when I was talking about the different streams is you have a executive order that has now shifted how things are going to be done. And the point of the executive order is to shift it to the states and to different agencies that have never administered these programs before. To what extent states and the HHS will continue to replicate and do what the Department of Ed does in terms of oversight, enforcement, guidance, research is unknown at this point in time. That is, and we're going to get to why it's critical because we're still in the time period that we can make differences, right? Because if we know where things need to go and we know what things need to be done, we can fix it. And that's how we're going to end this is, so what can we do? So first is identifying those different areas. And the areas really include of how now is OCR or who is going to be overseeing complaints. There are two different avenues that you as parents and advocates can take now. One is the IDEA does require every state to have state complaint processes, not only for due process, but also to a certain extent, but much different than what OCR did, but a state complaint process where it's someone at the state who comes in and investigates. Typically, my experience has been, and throughout my history, I've been able to practice in, I've had cases in Virginia, Maryland, DC, Delaware, and Pennsylvania. So I have a little snippet of kind of education. Um, that state evaluative process can be more rigorous or it can be less rigorous. So whatever state you're in, I would be looking to say, now what is our state complaint progress? How rigorous is it? Because if things are being shifted to the states for enforcement under IDEA, we're not going to be able to be looking to OCR. You are going to need to be looking to your state agencies. And again, every state's supposed to have one. So you say, well, how do I find that out? You should contact, starting information is really to contact your local disability services. Every state has, candidly, a parent advocacy, and they're called different things. Pennsylvania, it's called Peel. In Delaware, it's called Pitt. But there's parent training centers that are federally funded that exist in every state, and they are able to help parents. So that's a great resource to start contacting, especially now when you have questions. So we have this kind of shift to the states, right? And that is, again, an unknown. But what we do know is we need to, and again, follow up on this complaint process. Um, the other thing that's shifting to the states to a certain extent is program guidance. And every state has a Department of Ed. There's a Pennsylvania Department of Ed, Delaware Department of Ed, Virginia Department of Ed. Every state, they're now going to be given and responsible for giving guidance now to districts. Historically, there has not been consistency in that type of guidance. That's why the Department of Ed existed, is for that consistency that if you knew you had a kid with an IEP, when you walked into a district in Virginia, it meant the same thing as if you walked into a district in Texas. That was consistent. That consistency is going to go away, but that's going to make the advocacy at the local level and state level much more important because we are not going to have a level above our state educational agencies to be able to tell districts how to enforce and what it means for IDEA. For example, IDEA has a lot of wiggle room in it, and one of them is for reevaluation reports. So if you read the IDEA in terms of literally the black and white letter of the law, it says reevaluations are to occur, on a periodic basis. In state of Pennsylvania, that's very clearly every 3 years. It's in state law. In other states, it's not codified and there's no timeline on it. So how it's interpreted when evaluation reports can occur is a very state specific situation. If there's no guidance, that theoretically means that periodic reevaluation could be every 5, 6, 7, could be every year. But again, there is a lot of wiggle room in the IDEA in terms of that guidance. So looking to the states for that guidance is really important. There's a piece out there that I don't know how it's going to be picked up or where it's going to be picked up, and that's the research. And oftentimes people say, well, this, education is a science. And I say that in the sense of it isn't just how we feel about things or what we think about things. We create curriculum of how to teach kids to read, write, and do math based upon research. And that research has occurred a lot of times at the federal level. One of the things that the Department of Ed did was have a What Works clearinghouse. And what that did was look at different curriculum and the studies and say, does this reading program help with fluency? For example, I'll give you a real life example. Corrective reading. Corrective reading is a research-based reading program that a lot of districts utilize. You could go to the What Works clearinghouse and look at that document and say, because the Department of Ed would go through and look at the research and then make a document to say, is this really research based? Does this really help kids? And so when I would have situations, we'd go to the districts and they would say, well, we're going to use corrective reading. I could pull from the What Works clearinghouse and say, well, the What Works clearinghouse establishes that corrective reading really doesn't have the necessary components for this child whose deficit is decoding. That's really only been proven true for this aspect of reading. So we need something different. Who?
Heidi, we already have some questions, so since it
Oh,
looks like they're going to keep coming, I'm
okay,
going to butt in right now and ask a couple of
sure.
these. So, the one question was, has the Department of Education moved to the Office of Human Services already?
It started to move on March 21st, 2005. How many of those services have been moved over isn't quite clear, but the process has clearly already directed to begin.
Okay. Also, there was a question about um, this is an unknown, but it's about the parent resource centers. If they're federally funded, will they continue to have this funding? Um, from the policy kinds of calls I've been on, that's still up in the air, but right now that funding is continuing. Do you have any additional information on that
Yeah,
one?
that was one of the things that was concerning right off the bat. So far, they have not been notified. None of the parent training centers have been notified that their funding right now is set to be cut. However, whether or not that exists true 2 weeks from now, I don't know.
And then one more here is who will now police the process when districts are out of compliant with the student's IEP?
Okay, so that's a great question. So there's different avenues to police compliance, right? One is you as a parent. You have, and here's like the good news. The IDEA and Section 504 still exists. Inherent in each of those documents is your right to a due process proceeding, your right to mediation, and other alternative dispute resolution mechanisms that may exist at your state. So you could absolutely still pursue a due process hearing, still pursue mediation, and pursue your own advocacy for your child. Layers on top of that would be a situation where there is, again, the state complaint process. By that I mean is each state is directed under the IDEA. If you submit as a parent a complaint to the state, it's called the SEA and the IDEA. So it can be called something different in yours, but the state educational agency is supposed to provide oversight, similar to what happened at OCR, which is a state investigator was assigned to your case to go in and review your case of whether or not they did the PT, the permission to evaluate timely, whether or not they were following the procedural guidelines, whether or not they had the right people at the IP meeting. So you still have that state educational agency complaint process available to you. OCR still exists it's still in existence. The difficulty is the staffing is no longer at the same levels. So to what extent the effectiveness of OCR will be is what we know is there was already more cases than people present to be able to do it. They've cut people, whether or not more staff will be added or what will happen with that. But right now, OCR is not going to probably be your best first shot of getting things resolved in anything of a timely manner. So that really is in terms of the complaint process for enforceability that you still have. To what extent the states will step in and do more for complaint processes, I don't know. In Pennsylvania, for example, we have a lot of different alternative dispute resolutions, such as facilitated IEPs, facilitated hearing officer conferences. So there's more here. What exists in your state, you'd have to contact your parent training center.
Okay, there's one question, and I think you've dealt with some of there's a couple questions here. One is if IDEA and Section 504 are transferred to HHS, wouldn't this just be a rebranding of the same thing? And another kind of related question in my mind is since IDEA went into effect prior to the establishment of the Department of Education, um, don't we already know that the Department of Education isn't necessary?
Okay. So just so I can repeat the first question, which is the question is, hey, are we just basically moving puzzle pieces over to someplace else? So really there's going to be no fundamental difference. Is that the
That's
question?
yes.
Okay.
Hmm.
So that, and I think that that's a philosophy that a lot of people have here. And then I'm going to tailor it into the next question. So here is what we do know. HHS has no experience for the last 50 some years of implementing IDEA. So anytime, and it's just common sense, you move something to some place that has no experience doing something, you're not going to get the same experience that you had before. Could be better, could be worse. That time will tell. But what we do know is it's an agency that has no experience or expertise for at least 50 years of implementing these programs. So how that will play out, we do not know. The second issue is staffing. Right now, staffing is being reduced to, and programs are being reduced. So to what extent it will have the same experience, we can already know that it will not be. I mean, there's just no question. They are eliminating programs, they're eliminating staff. So what historically has been the experience will not exist. We had, and I'll just give you an example because one of the questions I always had, which is and what, well, okay, if we have these state complaint processes, how is that not just exactly what ODR or OCR did, right? Same thing, I mean, state people. You have at OCR, you had attorneys who had experience in education who were overseeing the complaint process. At the state level, you have a person who is trained on it, not the same level of expertise. So when you go to a doctor's office, it's kind of like you might be going to see your family doctor, but if you have a very targeted concern, you may want a specialist. And that's kind of the difference is you're having the same quote unquote experience, but the level of expertise is going to be different and the level of experience is going to be different. I mean, the reality of this, and I say this as someone who's trained a lot of people, it takes time to get understanding how to and the intricacies of education. Just having to know what the law is, it's not the same. For example, when is a permission to evaluate triggered, right? It's when a change in educational services. So if you have a kid has a change, when should that have been triggered? If we could all have that definitive, we know that this point in time, we wouldn't need it. We could do chat GPT. These are very fact specific, knowledge based decision makings of whether or not districts have complied with IDEA. We are moving to people who have never done it before.
So a
Oh, and then
couple,
the tailoring is the last question. What was the second question? Because I'm not sure I answered that.
I think you kind of have, you've been
Okay.
speaking to it, but the idea that if the Department of Ed wasn't created until after IDEA went into effect, did we ever really need it? And will this really have an impact?
Yes, and I
But
did
I
want to
think,
answer that
yeah,
specifically. Yeah,
okay.
so yeah, because and I'll tell you the reason the Department of Ed was created was because prior to the creation, When the states were responsible for it, they were not the kids with disabilities were not receiving the same level of services. For example, the research-based reading programming, I'm old enough to remember that that didn't really even occur when I started. So back when I started practicing in 1999, special education was you got Hoot and Mifflin, and if you were in special education, you got Hoot and Mifflin slower. You didn't get research-based reading programs. It was the Department of Ed that pushed through the national reading panel and the research and started promoting and pushing districts to utilize research-based curriculum. And that actually was part of the push, bluntly, when the reauthorization occurred in 2004, because we knew more. We knew there was a science of reading. We knew to be able to push forward for research-based instruction. That is why, and that is bluntly too, one of the importance of advocacy groups like LDA, because LDA was very involved, along with other advocacy groups, in pushing forward the requirement that there be research-based and evidence-based curriculum. Prior to 2004 reauthorization, that actually was not even in the IDEA. So part of that Department of Ed and the criticalness of enforceability did fundamentally change how kids learn to read today. And that's bluntly just one example.
A couple other questions. Someone is asking about the lawsuit that was filed by a group of states about Section
Yep.
504 and what the impacts might be and the status of that.
Yes, Texas v. Becerra. And then, just so we're on the same page, there's also another lawsuit by different states pursuing the EO for the Department of Ed. So the Texas versus Becerra was actually predicated on the Section 504 regulations put out by the Biden administration. That was filed. Subsequent to that, those regulations kind of came into questionability of whether or not the Trump administration was going to continue it. The current status as of today with that lawsuit is it's effectively to a certain part on hold. It has not been dismissed. The specific part regarding the declaration of Section 504 is unconstitutional has not been withdrawn, but the states have asked for it to be paused pending what they believe will be the Trump administration withdrawal of those regulations. And therefore, what they've alerted us to, at least the last status, is they now believe the lawsuit will be mute. So it's less of a concern, bluntly, than it was, I would say, I don't know, a month and a half ago. But we're still not at the point where we can say it's not still something to keep our eye on.
Okay, I don't know if this, if we should keep going with the questions that keep coming, or if you want to
No,
speak a
that's,
little bit more.
I think questions are great because, I mean, in all candor, there's so many different things competing right now. I think answering the questions helps. I like the dialogue more, especially when we're in the unknown time periods, because I think the questions help.
Okay, so here's a question is that I'm confused as to how state sped complaints, special ed complaints can replace OCR complaints, because my understanding is that the basis for a state complaint is an alleged violation of special education law, whereas the basis for an OCR complaint is an alleged violation of civil rights law. So state education agencies investigate completely different alleged violations than OCR, or am I wrong?
So special education is a civil right. Special education administered at the state level is still a civil right, but the states, it, yes and no. So special education complaints, I don't, and I'm not alert. And if I gave the illusion that I think that they can replace OCR, I don't. I think they both had their importance. What I'm saying is that there are still other mechanisms in existence without OCR that you could possibly do. To say that I personally believe that that is a replacement for OCR, I don't. I think OCR had at a much higher level ability to investigate complaints both at an individual but systematic level and really make enforcement changes and remedies for parents. In terms of your state complaint, so for example, a state complaint, if you allege that your child did not receive a permission to evaluate. You could, and that they didn't complete the evaluative process appropriately. Your state will investigate that. That is still special education, which is a civil right. OCR could also investigate it. The reason I'll be blunt, and again, I'm just being very candid, and I would always recommend OCR do the investigation or file a complaint because most of the time state educational agencies, at least in my experience, are more looking at checking the boxes, right? So as long as there was a PTE, check. As long as they had a situation that they had an evaluation that they could show you a document that state would do check. OCR would investigate that further, which is did the permission to evaluate, really evaluate all suspected areas of need. They would go further into that evaluative process versus a state, which is more procedural in nature. What will happen and what we don't know is will now states be expected to now do more and replicate more of OCR? Bluntly, the states have never been expected to do that. I don't know where the funding is going to come for that to occur. And I don't know what states are going to be willing to really kind of step up and do that. And that's, again, part of the advocacy as parents of pushing, your different levels of government, your federal level, your state level, and your local level to ensure that our expectations of how our kids with disabilities are going to have that enforceability is important.
Okay, another question. My understanding is that a significant amount of DOE employees have moved over to HHS, especially around special services education. Is this correct? And if so, doesn't this mitigate the concerns around experience in the HHS department?
Basically, everything is supposed to be already over in HHS. To what extent they are or not, correct. If they're continuing to employ that, the difficulty is again, I'm just using OCR as an example. They are now considered part of HHS. OCR is now considered part of HHS, but they have eliminated the staffing and OCR. So the reality is although OCR exists, it does not exist to the same extent that it existed prior under the Department of Ed. So while there was 17,000 complaints and there might have been 200 people being able to staff it, you're now down to a group of 50 people doing the same level of complaints. So you're going to not have the same type of experience in terms of OCR. In terms of the experience overall of the personnel, to what extent HHS, because they've just taken it over, to what extent HHS decides to replace the Department of Ed people with their own people, the department, whether or not they keep them, that is all stuff that we don't know. What we do know is HHS is now responsible. How they are going to carry out those duties is an unknown situation. Whether or not, again, they continue to employ the Department of Ed people, replace them with their own, eliminate further departments, that is all stuff that we're transitioning through.
Yeah, and I also understand from some of the policy calls that we've been on, that there are people who have just lost their job. They weren't transferred to HHS, they just no longer have a position. And I don't know that we know exactly how many that is or exactly what departments are most impacted, but that's my understanding. I think you've already answered I think you kind of answered this, but someone asked who will be enforcing the timelines, retesting deadlines once parents request an assessment for their child.
Okay. So let's kind of go through that process. The first people responsible for ensuring your child receives FAPE is the school district, the local educational agency. They're the people tasked with issuing the permissions to evaluate, doing the evaluative process. So that's not going to really change because your district is who they were before the Department of Education and who they are now post closure or post reduction. So that experience is not fundamentally probably going to change. Now, there will be at the local level some more changes more quickly. So I'm not sure again how in tune people are with the news, but in Ohio, because again, a lot of what happens in school districts is actually state and local. So, for example, in Pennsylvania, we do not have any type of way to we have school choice in the sense of we have charter schools, but we don't have like a voucher system or open enrollment or other things other states have. So in Ohio, they have what's known as open enrollment. And that is where, and I don't confess to be an expert in that system, but so I'll use my nine, whatever 180-degree above viewpoint of it is. But it's this option where you could enroll in other school districts over a period. And so you could have your child attend a different school district than your district of residence. In Ohio, a district said all the kids that they had accepted through open enrollment who had been part of their district who had kids who were kids with disabilities were no longer able to attend that district due to financial issues. Historically, that is bluntly discrimination. You can't just say we're going to take the kids with disabilities and say you can't come here, because again, that's discrimination. You wouldn't say that to the girls. You can't say all the girls, sorry, you just can't come here. All certain race, you can't come here. Certain religion, you can't come here. Certain, whatever it is, protected class, you could not say that. That has now occurred. To what extent that is going to be allowed, the difficulty, and this is kind of what the truth in the pudding is, as someone who has sued school districts and I'm on school board, it is a situation where districts do things that are not legal. I mean, they do. It wouldn't exist if they did. But at the same token, unless someone pursues a lawsuit or pursues some sort of oversight to that action, there's nothing stopping that from occurring. Because if I just said, you can't come here, if you just go away, well, then you couldn't come there. So to what extent what has been foreclosed is the avenue of, in terms of OCR, not that that's foreclosed per se, but any timely resolution of that. So, for example, let's say those kids filed an OCR complaint. The timeline to which that would have been resolved probably is not going to occur before the start of the next school year. So now you have kids who, even if it turns out that they are correct, are going to be in situations where they may get that resolution, 12, 16 months from now. So parents are then left with filing due process complaints. Well, bluntly, for a lot of parents to be successful in due process or federal court or, your state courts, you need attorneys. And attorneys are expensive. I mean, I'm $550 an hour. That forecloses a lot of families from being able to afford the legal representation. So then now you're down to your state agency and to what extent your state agency has complaints that you can pursue for that. That is really the question. So you have different levels of support. What has happened is the federal level, which it is a federal law, is now no longer as effective or has the personnel to be able to do the complaints as they did previous. Now and listen, I am not a Department of Ed was, God's saving grace, and it was the perfection upon that the mountain was built. But at the same token, if the criticism of the Department of Ed was that it was slow in not doing OCR complaints, what I can say is that process will be now slower.
So one question that's related is what will happen to those prior complaints? Will they, that are already at OCR, will they still work on them or will they be transferred to the state? Do we have any idea?
So there's really no mechanism for OCR that exists at this point in time for OCR to say, I'm going to give it to the state. So unless there's, again, internal mechanisms that occur, states have to have an agreement for that. So they will stick with OCR. And I'm just going to be practical. I think what will happen is they will weave them way through the system. I think a lot of times by the point in time a decision that complaint comes to the forefront of like, okay, now I'm working on complaint 156. The first call is probably going to be from the investigator to the family to say, is it still a current issue? And if it's not, if the kid's graduated and it was this kid did not have an access to appropriate busing, or at this point in time, the kid's now attending a different school district, I think a lot of times they will end up just being considered resolved or moot, and no longer have to be investigated because probably at the point in time they reach the investigative stage, it it's not going to be an active, case or controversy. So I think a lot of it's going to be parents having to figure out different avenues to fix situations.
Okay, so another question, and this one of the things we've discussed before this webinar started was that Heidi will make this more of a monthly kind of opportunity because we really don't have all the answers right now. Things are evolving, and that is related to a question asked by someone about the What Works Clearinghouse. Will that be picked up either by HHS or some private entity? And I don't know that we have the answer to that at this
We don't
time.
have the answer to that, but I will say is that there is guidance that has already been taken off the online. So, to what extent you as a parent have ever relied on a dear colleague letter, an OSEP memorandum, anything along that line, my advice is to print it off because these things are not being rescinded. They're not being like, even if it's not online, it doesn't mean it didn't exist, but your access to having a copy of it to be able to show to a school district is going to be limited. So, as much as you can to anything that you have utilized to bring into IEP meetings, you should be downloading. I know that in terms of the LDA, that the LDA has taken somewhat of a role of trying to download the most important ones from that perspective. And I think that that's one of the things that I tell people as something you can do is download the guidance because if it is taken offline, and there's already been ones that have taken offline, you still have access to it.
Okay, so also a related question. If somebody had already, if a parent had filed a complaint, an OCR complaint, should they be refiling at the state level?
Uh, my advice right now is if you have a complaint for your child, you should be pursuing all the different avenues because again, there is such a upheaval right now. If you have a complaint, yes, I would file it with the state. If you can file for a mediation situation, the two quickest routes, I'm going to be blunt, is due process and mediation. Those are your two quickest routes for resolution. In terms of an outside investigator, the state educational and OCR, but yes, I would file with both. And you are not precluded from doing that. You can actually file the same complaint at each different level.
Okay, one person is asking, what's the likelihood that your student who is I think what they're saying, what's the likelihood if of things that a student is currently getting can be taken away due to a new standard of operating procedures and new requirements of what actually is a disability by HHS?
That's a great question. Okay, so we're going to have to get into, I'm going to try to make this as user friendly as possible without getting too technically legally. So prior to this past year, we as lawyers, when agencies like Department of Ed, Department of Transportation, any such department, EPA, FDA, issued quote unquote guidance. And that's kind of what is termed of our administrative regulations. And that was really the meat and potatoes of how to implement things. So that would give you, because if you read the IDEA itself, it's very broad, but the actual implementation of it was really, we would get that information of, okay, so it says we're supposed to provide FAPE. Well, how do we do that? Well, then you'd receive the administrative regulations, like you have to convene an IEP team, and here's who makes up the IEP team, and here's what an evaluation has to include. So we'd be like, okay, now we know. And the way prior to this past year, the courts were required to interpret it. In the court case that decided it, I think it was under Reagan, the Supreme Court, it was Chevron. It was the Chevron case. And Chevron said, when these departments, like the Department of Ed or Department of Human Services or whoever says these regulations, this is speaking for Congress, meaning that this is what Congress's intent was when they wrote that very broad language. So even if the law was written, for example, right now in 2004, IDEA, if the Trump administration had, and Chevron still existed, if Trump's administration put out guidance, it would be like, that is what, even though the law was drafted in 2004, that is what the congressional intent of 2004 was. Well, the Supreme Court this past year, and I think it was Loper, I don't remember the rest of it, but it's Loper v. Bright, I believe, said That's no longer true. You no longer, courts do not have to defer to these administrative regulations with the same level that it's speaking for Congress. So all these orders, executive regulations, they no longer have the deference as speaking for what the legal intent was. So what that fundamentally means is the department, let's say the Human Health Services now puts out new standards, regardless of whether or not they're better or worse. It truly doesn't matter. A state and your local educational agency could say, well, that's nice. That's helpful, but that doesn't get, I don't have to follow that to the same extent that I did before. And neither do judges have to adhere to it as if they listened to it as they did before. Neither do administrative law judges. No one has to look to this now as basically the word of Congress. It's more helpful information. Now, again, that's the state of the law right now as this weaves its way through the system because we're all dealing with the impact of the loss of Chevron. So, to what extent those administrative regulations now have, I will say, and again, this is an example. So, that is one of the ways there was a Title IX case out of Kentucky that basically completely vacated the administrative regulations that Biden had put out under Title IX, in large part because they said this is not what Congress intended. And I no longer have to give the deference to those administrative regulations like I did before. So there's precedence in education right now that whatever administrative regulations are put out very well could be vacated and not have to be followed. And again, for good and for bad.
There's a couple questions about funding and what will happen to, I think it's teacher education funding, Title I, II, III, all the different funding streams.
So some of that's unknown. They have been cut. There will be cuts to funding because that's part of the executive order is to cut things. So there will be cuts. Where it will be cut, I don't know. Inherent in that is a second thing that brings up that I haven't spoken about. And this is stuff that I think everyone I was made aware of because of I'm a school board member. But this past week, the Department of Ed sent out to all districts, every district in the entire nation, an attestation form that you have to warrant that you are not doing any type of DEI training in line with the executive order previously issued. There is already a pushback by certain states and certain districts because diversity, equity, inclusion is inherent in the IDEA. So it is hard for districts, and we still don't know what we're doing as a district because we do DEI, because we do inclusive activities for kids with disabilities. We do equity for kids with disabilities. So we are doing DEI. So there is a question of whether or not, because the threat is that if you don't sign this form, you're going to lose all federal funding. Now, so that's kind of a secondary issue is that there's a local level of funding. At the department level, I don't think, I'll be blunt, the long-standing like Title I and stuff probably will not be, just given kind of the administration's and the way I see the wind blowing, and this is truly the wind blowing, nothing more than just looking at the decisions that are being made. I don't think those type of funding is probably going to be disbanded. I think you're going to see more of the research, the trainings, the other ones that are not specifically related to title funding be the first to go. To what extent others go at later points in time, that I don't know. But I think on the hierarchy, those I'm less concerned about than the other ones.
Okay, one more question. Do you think that states will be able to dissolve IEPs or special education in 504 programming, or will IDEA and Section 504 protect that from happening?
So the states have no ability to, so in our hierarchy of laws, there's what's known in the Constitution as the supremacy clause, which means your state can give you more rights, but your state can't take away your federal rights. So shockingly, and I used to talk about this during COVID, and people were actually kind of shocked. Most kids don't have a federal right to education. Your right to education as a regular education student comes from your state. So theoretically, your state could eliminate your right to education. If the Constitution is rewritten and they say you don't have a right to public education, your state can take that away. Your right to education at a federal level is for kids with disabilities. So it's really the kids with disabilities would be protected. So states could take away educational rights of students. They could not overrule, though, the federal right because of the supremacy clause to take away the rights for kids with disabilities. Now, whether or not a court found your right, like Texas v. Becerra, Section 504 unconstitutional, whether or not IDEA could be found unconstitutional, that could happen. I am unaware of any lawsuits regarding the unconstitutionality of IDEA. There is the one for Section 504, but it is on pause right now.
Okay. I think maybe one person did ask a while ago, and I think you've kind of alluded to it, cost savings, but why? Why is this even happening? What is the motivation behind dismantling the Department of Education?
I mean, I can only speak to what's being said, and the idea behind it, my understanding, and the way it's being explained in the fact sheets and from the administration is that it's the intent to return the education to the rights of the states. The the difficulty, and again, I'm just going to be very candid, which is we are not talking about state educational rights. We are talking, the Department of Ed really did not touch those. The Department of Ed touched the federal rights for kids with disabilities. So it is the probably the most in likely in terms of where you're going to see something is that funding, though I'm not sure how this is going to occur, is that some of the fundings from like the different titles and the different things, instead of being administered by the Department of Ed, are going to be administered by HHS. So I'm not sure exactly how it's giving states more. I'm not sure how they're connecting the dots because again, the Department of Ed had nothing to do with, the guidance in terms of the state regular education students. The Department of Ed was giving the guidance. Now there's some research that was important for kids, all kids, like learning how to read, that did help for kids with, even regular education kids. But for the most part, the Department of Ed, in terms of what we're talking about, did not exist for regular their involvement did not touch upon kids with regular education needs. Now, Title IX did, but in terms of IDEA and Section 504, it really only touched upon kids with disabilities.
Okay, one question here is about students who are in out-of-district placements. Is there anything that families and parents should be doing proactively to try to keep that funding and that placement in place?
Okay, so that's a really important question because as much as I could say as a lawyer, and I'm going to, speak like a lawyer and I'm going to speak at practical purposes, is funding is not supposed to be what drives kids programming. It's not supposed to be like we have a pot of money, you only get so it's what's supposed to drive it is what the child's needs are. In fact, if you go to a due process proceeding and said, well, we'd love to, but we just don't have the money, that's actually not a legal escape clause. So in terms of that, there's nothing you need to do because programming is not supposed to be dependent upon how much something costs. Now, let's just be real, right? If there's not any funding and there's no money for it, the districts can't pay for it. And the districts aren't going to tout it. They may not even be as direct with you and say it's not based upon funding. It's based upon, no, the needs of your child don't warrant that anymore, is probably more likely what you're going to hear. So what you really need to do in terms of is to figure out whether or not there's a problem. And I'm going to be very candid with you, is, and we saw it with COVID, the local level has a great impact on you because your experience of what happened with your school district during COVID varied very dramatically. Even your neighboring school district could have had in-person education while you're still virtual. They could have had hybrid while you were completely virtual. So one of the things I think you need to look at is going to a finance committee meeting of your school board to figure out what the financial state of your district is in. Because I can tell you if there is a financial downward trend in your district, that will be noticed to you that the money is problematic and you might be more risk. If the funding is not a problem and there is no, I wouldn't be as worried about it. Now, in terms of just what you can do overall to ensure things, is make sure that you get progress monitoring that's establishing two things. One, that your child's need, they're progressing, they're making educational progress, but two, that the need still exists for the level of out of district placement that is occurring. Because that's really what the judgment is it a situation that this program is needed? And is in this program, is the child making progress? So you want to make sure you're gathering as much evidence regarding those two areas that the need still exists and that the child's making progress to establish that that's the appropriate program of placement.
Okay, we got three really good questions. One's related. Someone asked, isn't a majority of funding from the state and local level?
Yes.
Yes, but I think what you were saying is that your state's, I mean, your district's financial situation is what is going to drive whether or not they will argue, no, your child does not need that
Uh,
placement. You can
I'll
meet.
give you an example. In my own district, our funding is less, federal funding is less than 1%. However, right now in our district, we are, because commercial property post-COVID has been, and people are working virtually, we're not getting the same level of state and local taxes from commercial properties. So financially, we are not getting as much money prior to COVID than we were before, which is putting us in some programming changes that we have to look at in our district. So that's why going to a finance committee to figure out exactly what's happening at the local level is bluntly more important than what's happening at the federal level. Now, I will say other districts, they may be getting a lot more federal funding than that. It could be 20% of their total budget, depending on the state.
Okay, so this one should be a quick one. How do these changes affect non-public schools? And the example was charter schools. I think this is an opportunity to clarify that what charter school obligations are and the fact that they are indeed public schools.
So charter schools are public schools. They are required to follow it in a they're required to follow the IDEA and Section 504. Most of the time, for example, in Pennsylvania, charter schools will also have a separate state code that governs them with special rules and regulations, especially when it regards different entities. But yes, they have the same obligations as a public school system has to provide the same level of supports and services. How charter schools are set up, I've had experiences where charter schools have been the most fantastic, best thing, and other ones where it has not been a positive. So it really depends on your area. I think different states, charter schools are more well respected than maybe in our state of Pennsylvania, where it's not the same level.
Okay, and here's a long one, but a good one. Federal rights from case law has been created. However, the IDEA ties states' receipt of federal funding with compliance with the IDEA. A state could determine that it no longer wants federal funding and do away with the implementation of IDEA in its state, thereby affecting IEPs, assessments, provision of special ed, etc. Could it not?
So could the state not receive any funding and say that we're not following it? Theoretically, yes, because it is predicated on that, but a local school district could not. So if your school district could not say, well, we're not going to take, like, let's take my district, it's 1% of the budget. Theoretically, could my district say, well, we're just not going to take federal funds? That we could do that, but we would still be under the obligations of IDEA and Section 504. And again, the funds that states receive, there is still a significant amount of funding that states receive from federal funds because understand it, it's not just IDEA funds, but there's other federal funds that exist. So whether or not you could parse out, well, and that would be a court case. Could you say, well, I'm just not taking IDEA funds or education funds, and therefore I'm not following that law? Or would you have to forego all federal funding? Because again, for us, the attestation form says that we would receive no federal funds, and that goes beyond just funds for IDEA. It goes into funding for other programs, the grants you receive for school safety, for the police officers. So again, I I'm not as concerned about that, although that is a very good question and one that I think is more nuanced than it may seem on the face, if that makes sense.
Mhm. All right, well, we actually, oh, there's a question about, are there plans to impact Medicaid reimbursements for services provided in school setting? Do you want to address that or?
Yeah, so a couple things. One is to what extent the funding is in existence is we're working through the budget, right? So there has been some state laws being promoted. I believe it's Oklahoma, but I can't guarantee it. And I read because there was a concern initially, which is something about the way the law was reading. It actually didn't concern me as much because what the law is this is the payer of last resort is the school district. And that is why districts could seek funding for reimbursement of services. So, for example, if in our state and all the IEPs, it has bill backs. So we get a portion back for our speech and language. We get a portion back for our OT. We get a portion back for our one-on-one. We get a portion back for nursing services. Because again, it is a very intertwined system. I believe the law in Oklahoma, and again, I could be wrong at the state, said something about districts are no longer do not have to provide medically necessary, or basically services through medical assistance. Now, theoretically, that would really just present an issue that the services that are being billed back could not be funded, but that wouldn't negate your child's right to those services for educational purposes. And there is an overlap. And to say there isn't in anything, what is purely medical and what is educational, there is an intertwining and an overlap. So what could happen in states where districts are no longer able to bill back because they're forbidden from doing medical services is this delineation of what is medical and what is educational. And bluntly, if anyone could ever define that in 25 years, I've never been able to find a doctor, even bluntly, Monica, a school psychologist who could parse out specifically what is a pure medical need versus what is an educational need because those needs are so intertwined.
Okay, well, we are already a little bit over time. I see another question about getting a transcript. I think what we're going to try to do is maybe do a Q&A type of document that we will send out or post on the LDA website based on this transcript that we have from today. And like I said before, Heidi has agreed to do this type of webinar periodically because things are changing very rapidly. And we'll probably have more information at a later date. Heidi, do you want to say anything else before we end for today?
Yeah, the ending statement is this, is that we've all, as parents, and I'm a parent of three kids, we've always had to be advocates for our kids, right? At every IP meeting, we've had to advocate for our kids. At this juncture, our advocacy needs to go beyond just purely the IEP meetings. As much as you can at the local level, be meeting with other parents with disabilities to pursue your local levels, as much as you can get involved in state advocacy, as much as you can get involved in national organizations. There is power in numbers of ensuring that is how we got to the place of having protections for kids with disabilities. And that is how we will ensure that these kids with disabilities needs are still being met.
Okay,
And
and
that's
before
it.
we end, just to follow up on what Heidi just said, if you're not a member, please consider becoming one to make our advocacy voice even stronger. And thank you for joining us today.
Thank you.